everyone, Chris Myers here with the Orlando Property Group, Orlando's top short sale team. I'm here with Chris Cruzada of Nijam Law Firm, and we're going to talk to you a little bit about deficiency judgments in short sales and also the tax ramifications. I guess we'll start with the tax ramifications, and we'll ask you, Chris, if this is correct. You know, back in what, I think January of 07, President Bush signed into effect, what was it called? Mortgage Debt Forgiveness Act.
Correct.
Whereas if you have lived in a property as your primary residence, your homestead residence, for at least 2 out of the past 5 years, the loss that the bank takes or the deficiency will not be counted as debt forgiveness, and the IRS will not tax you on that as income. Is that correct?
Well, the basis of the IRS pursuing anyone for a tax liability is because there's income being realized. And
right.
when someone's debt is forgiven, the IRS definition of income comes into play, because any forgiveness of debt to the IRS is considered income. And when a lender goes ahead and says, hey, I'm forgiving this debt, I'm going to 1099 you for that difference. And that difference is what is sometimes referred to as a deficiency. It hasn't been turned into a deficiency judgment yet, it's just a deficiency. The lender has two options. It can try to pursue the borrower on that deficiency and turn it into a judgment. Or it can 1099 the individual and say, hey, listen, I'm going to report this to the IRS that it is income to you. I've forgiven it. I'm taking it off my books as a receivable coming into the lender, and you're going to have to pay taxes on it. And
so
what you had said is correct, where in 2007, the Mortgage Debt Forgiveness Act allows for a person that's lived in a home that is considered their primary residence to not have to pay taxes on that forgiveness of debt.
Beautiful. So, for example, if the bank forgives $30,000 on the loan, say, for example, you owe $130,000 after the short sale, the bank's going to, receive $100,000 from the proceeds. That debt forgiveness is $30,000. If you've been living in the property 2 out of the past 5 years, your primary residence, you're not going to have to pay taxes on that as if you earned an extra $130,000. If you're an investor, though, or it's a second home, you'll want to consult your tax accountant, tax attorney to try to figure out if there's a way you can minimize that impact, because you're going to essentially be taxed as if you earned an extra $30,000 last year or this year.
Correct. And because the mortgage debt forgiveness doesn't apply to investors, and that is the reason why.
Okay. Now that brings me to another question. Deficiency judgments, something we as, real estate professionals working with short sales, our ultimate goal is to try to get the bank to waive all deficiency rights, meaning they cannot come after you for any additional money in the future. Sometimes the banks will reserve that right and not budge. We see it waver back and forth. There are times when they're firm, they won't waive any deficiencies. Then they'll change their policy, they'll waive it easily. But the 1099 is kind of what you're hoping for, because once they 1099 you, they've
written off that receivable and taking it as a loss.
Yeah, so they can't come after you for a deficiency after that.
They can undo it, but it would be so much paperwork to then report to the IRS to say, no, we want this back as a receivable, we're going to make income off of it, and then they have to send you something to undo that tax liability on that 1099. It's a lot more difficult. That's why a lot of lenders
very unlikely, right?
Yeah, a lot of times though they will hold off on these deficiency judgments until a later date, to make sure that they won't get paid or they will get paid.
Okay. And now, if the bank reserves the right to pursue a deficiency in the future, it doesn't necessarily mean they will come after you. They may.
Correct.
Now we're seeing some cases where they'll start trying to send collection letters. We're seeing a lot of cases where nothing has been done yet. We don't know. Some, from what we hear, some people are speculating the judges are going to kind of take mercy on people if the banks come after them for a deficiency judgment. We don't know. It's speculation.
It is speculation, and I can't speak for what a judge would do because every case is a case by case basis.
Mm-hmm.
And if it goes to a deficiency judgment situation in front of a judge where property is foreclosed, the bank does get certificate of title and then sells it, and then goes back to the court and says, we sold it for this amount, this is how much it was owed, we've got a deficiency amount, judge, we want this deficiency judgment to pursue the remaining amount on the mortgage and note. A judge will make that determination at that point.
But it's more likely that the judge will grant that in a foreclosure than a short sale, right?
Correct.
Because in a short sale, someone is they've tried to do everything they can to minimize the bank's losses. Foreclosure, they didn't try to do anything really.
Usually, in a foreclosure, the certificate of the property either gets sold on the courthouse steps, or a certificate of title is handed over to the lender.
Right.
And the lender assumes ownership of the property. Now, with short sales, the lender does reserve the right to sue on the promissory note. There's two aspects of the debt of owning a house. The promissory note is kind of like the loan.
The promise to pay. Yeah.
The mortgage is the security, the collateral for the loan. The lender has the right to foreclose on the mortgage and obtain the collateral, the house, to satisfy that loan. Or if it wants to, try to resolve taking the house and selling it, possibly through a short sale or through a consent judgment.
Well, like before it goes to foreclosure, what we're worried about is short sales. What can happen to a homeowner there? Now, our goal is to get the bank to waive any deficiency rights on both, on the note as well.
Sure.
So they can't come after them at all.
There are negotiations that can occur during the short sale process whereby the original borrower, who is now the seller selling the property, can negotiate with the lender for no deficiencies.
To wipe the slate clean.
Depending on who the lender is, it's their prerogative, and it's their choice as to whether they want to do that. They look into your financial situation, they look into your savings situation to get an idea of how much you have and how much you can earn and what you can pay back. Sometimes they'll give a promissory note back to pay it down over a period of time. Other times they'll just say, we reserve the right to pursue you at a later date.
Right.
There are statute limitations depending on what type of mortgage or promissory note it is. But there are statute limitations.
So if they've reserved the right, they usually only have about a 5-year window in which they can try to come after you, right?
And it depends on what type of promissory note that it is. If it's if it's federally backed by Fannie Mae or FHA, they may have some longer extended windows of statute limitations.
Okay.
If it's not a Fannie Mae or FHA loan, the statute of limitations period could be shortened. It depends on the type of loan it is. And I can't go into the details.
Without knowing the details of the case. Well, that's pretty much it. And another reason why it's important not to only have an aggressive and experienced real estate professional working with you, as well as someone who knows real estate law. And you need to have that two-pronged approach in many cases. So give us a call, and we'll be happy to help you out. All right, everybody, make it a great day.
Thank you.